seated, please. I wish we had the British tradition where everybody had to be upstanding like that. All right, I think we're ready for second case, AIRW et al. Versus City of Georgetown. Who's present for the appellant?
Your Honor, Jake Beach on behalf of TCEQ.
Andrew Davis on behalf of the developers, AIRW.
And you all, I'm informed, will be splitting time?
Yes, Your Honor.
Okay, you're going to keep track of it because I'm not.
We've spoken with the clerk, and he will set it for the time. It's going to be 9 minutes for the state.
Good,
We'll have 6, and we'll reserve 5 for
because when the
rebuttal.
time's up, I'm moving on, so keep an eye
Yes,
on
Your
it.
Honor.
And for the city?
Cody Falk on behalf of the City of Georgetown, and I will not be splitting time with myself.
Okay. You may proceed. Mr. Beach?
May it please the court. The trial court erred by vacating the commission's order, which should be upheld for at least 2 reasons. First, the Texas Water Code affords substantial discretion to TCEQ, requiring only that it use reasonable methods to encourage or promote the use of pre-existing facilities. Second, the commission reasonably exercised its discretion in this case because substantial evidence shows the city denied service, which in any event was not available because the city did not have Jonah Water's consent. Turning to my first point, the crux of this dispute.
Let me get just a little bit of background. So, why is it you don't want to be annexed by the City of Georgetown? I don't practice in this area, never had. I assume taxes are higher if you do that, or what's the downside to being annexed?
Yes, Your Honor. The commission found in this case that annexation by Georgetown of the applicant would impose a $20 million cost and $13 to $16 million
But it
of
was
that.
opportunity cost. Is that because you weren't going to be able to sell as much land, but you were going to be able to sell more land because you weren't going to have to put a wastewater treatment on the facility on the treatment? So what was the $20 million? Just because people wouldn't pay as much if it's in Georgetown?
Yes, Your Honor. So the $20 million alone comes from property tax that would be imposed on the property, but also there is a much larger cost that comes from the conditions and zoning and land use requirements the city would impose. Those
Is that
numbers.
the 80% commercial? Is that?
Yes, Your Honor. And so there's not even a numeric estimate because it would materially change the project to the point where it can't go forward. And so
Thank you.
Yes, Your Honor. And so when the applicant comes forward and is required to just look at the options around it, the commission requires applicant to look at within 3 miles, who are the pre-existing providers. That is a reasonable method to encourage or promote the use of pre-existing facilities. And that's all that's required by statute. So the Texas Water Code gives us 2 statutes here that control this inquiry. That's section 26.003, requiring reasonable methods to encourage the policies of chapter 26, which includes water quality protection, and consideration of the economic interests, and then encouraging and promoting pre-existing facilities.
Well, are you allowed to consider property values, though, when you're making this determination? And have you done so in the past?
Yes, Your Honor. The commission reasonably exercised its discretion in considering the costs imposed here by the city's annexation requirement. And the city's argument to the contrary relies on the website about public comments and jurisdiction. And that goes to the affected persons analysis. And in that situation, if you are a homeowner and TCEQ is considering a permit, you are not an affected person to come in and say, well, I don't want a water treatment plant down the street from my house. That is very different from when you are already an affected person and the commission is conducting the regionalization analysis set out by the Water Code, in which cost would be a reasonable method to consider whether a combination is appropriate. And so, again, when you go back to the controlling statute, it is highly discretionary. It affords substantial discretion to the commission, requiring only, again, the reasonable methods. And 26.0282, even there, the more specific statute says the commission may deny or alter based on consideration of need, which includes volume of the influent, but availability of the pre-existing treatment plant. And when you look at these two taken together, highly discretionary, availability is one of the things the commission must require. And that's where the web page comes in, is administrative record page 98, non-exhaustive factual circumstances that the commission would consider and guide in whether the regionalization policy is met. And the parties all agree at least two of these non-exhaustive factual circumstances would be relevant here. And the commission has suggested if there is a pre-existing facility within 3 miles and request is denied, that would be a situation in which a permit would be granted. But also, if there is a basis for an exception, looking at costs and other relevant factors, again, the commission has indicated it would exercise its discretion to grant a permit in that situation.
Mr. Reach, could you think of, I was pondering the breadth of the statute and the arguments you're making about the discretion. And I was trying to formulate in my mind, based on your arguments for TCEQ, what would a plaintiff city, let's say, have to show to shoot down a permit that's been approved on the basis of regionalization? What kind of facts would get them there?
Sure, Your Honor, and it would have to show, of course, that the costs favor the city and that there's other relevant factors that would discourage, that would just make it completely unreasonable, right? And actually, the thrust of your question, Your Honor, actually goes to a problem with the city's position, is that once the commission has encouraged an applicant to consider other options, and they have talked to other providers, if it's economically feasible to connect, they're going to do that. So when you look in the briefs and say, well, the commission is not denied based on regionalization, that doesn't show a flaw in the process. That shows that it's working. Because if they find someone else, it makes sense for their project, they're going to connect. Parties act in their own economic interests. You would have to have this hypothetical test case where someone acts totally against their own economic interests, comes to the commission, and can't show anything else counseling towards granting this permit. And that's just a difficult hypothetical to construct because that's not how parties behave.
But if you're counting in opportunity cost and assuming city taxes are usually higher than county taxes, and for all the reasons of density and zoning and all the other stuff like that, doesn't the result end up that your regionalization policy means cities are gonna be surrounded by wastewater treatment, privately owned wastewater plants?
Well, Your Honor, that goes to another part of this dispute, is that a majority of these regionalization determinations are controlled by a different part of the statute, and that's the exclusive designation of regional discharge. That's Texas Water Code 26081-086. That actually speaks to a lot of these situations, that if you're in a standard metropolitan area, the commission has discretion to order you to connect, and that would resolve this problem of all of the different treatment plants popping up. We are in the much more permissive, discretionary, case-by-case analysis that the legislature has committed to commission discretion. And in fact, the city's position, advocating that this court must accept a very siloed view of costs, that is not even supported by the more stringent analysis. Even in 26081-086, the commission must make an affirmative finding that that the order does not impose undue financial burden on the affected party. And so even in the mandatory regime, its financial considerations matter, economic realities matter. And so the commission was well within its discretion in the much more permissive regime to say, look, you put forward evidence, there's substantial evidence here of the significant costs that would be imposed by annexation, and conclude that that was an effective denial. For these reasons, we ask that the court reverse and render judgment for the commission. Thank you.
Mr. Beach. Mr. Davis?
Thank you, Your Honor. May it please the court? The trial court's decision here should be reversed and the commission's order affirmed because the permit complies not only with regionalization, but with all other legal requirements, as we explained in our brief. I will focus on regionalization here because that was the focus, but happy also to take questions about any of the other topics. So I want to start by answering, going a little bit deeper on some of the questions that were already asked. In particular, there was a question about what do we have to show? What would a city have to show in order to have regionalization? And I think really you have to think about that in two distinct ways. One is, what would they have to show for the commission to exercise its discretion to require connection? In that case, the statute is the easy answer. It says it has to consider need and has to consider availability. If it finds that there's availability, then it can make its own decisions based on the policy discretion that it was given by the legislature. Maybe that would be enough in this case if the commission had decided to do that. I'm doubtful, but perhaps that would be up to the commission. It's a different question, though, to say when can a court step in and say the commission had to force connection? I submit this case is easily within the discretion of the commission and not anywhere close to where a court should be stepping in to say that something has to be done because it's without the bounds of the commission's discretion to determine that as a functional matter, connection wasn't available and was extremely costly. There was another question about what would happen. Would you have a situation where you get surrounded by wastewater treatment plants?
So just one second before you keep going. So is effectively what you're arguing there that you would have to have ultra-virus conduct to have a trial court step in the way she did?
I don't think it would quite fall under ultra-virus in the sense that it would just be outside the bounds of the statute. It is, in a way, ultra-virus, but not in the way that I would generally think about this court sees ultra-virus, where you'd have an ultra-virus claim coming up. It would just be a normal claim from in the administrative context. But you're right that it would be the commission would have to act outside its statutory bounds of discretion and reasonableness in that context. When it comes to the situation of would you be surrounded, I think my friend did a great job of explaining that most of these regionalization issues are dealt with in metropolitan areas. That's the focus of the statute. We're not within this. But I think it's, yeah.
One interim question just occurred to me. I hate to interrupt you, but it's
Of course.
from the proposed development. Where is the wastewater going to empty into?
So there's essentially a dry creek right now. It would flow into that. It's like called Mankins Branch. It would then flow further, and I cannot remember the name of the tributary it runs into. But it's set out in the record, and we can always supplement if necessary.
Sooner or later, it's got to go to the San Gabriel, I would think.
I believe that's the case. That there's a few tributaries that go on the way, but eventually. And this is going to be, there's not going to be discharge for most of the year. Most of this water is going to be reused for irrigation. It will be rare that there's actually a flow. But of course, there will be a flow at some times, which is why we went and got this permit that meets all the requirements as the commission found.
So here, can we really say that that they've done enough where they didn't actually go, they didn't go to a city council meeting, right? And actually present it to the city council in any type of formal environment, right?
Correct. It was not presented to the city council for waiver in a formal way.
Okay.
But there's no requirement of that. I think the question of availability is a factual issue for the commission to decide. You'll find nothing in any Texas law that requires going to the city council for a formal decision.
So it's not an exhaustion issue?
Absolutely not. Certainly not in a jurisdictional sense.
Sure.
And absolutely not in the sense of it's a factual finding for the commission, and that's what it did here. And I think that's really brought to light if you think about what would be required here. They say, well, if you would have gone to the city council and they would have denied, then of course that would have meant that you had a formal denial, and that's it. But imagine what would happen if we had gone. We asked for a waiver, and the city council said, we're going to deny it right now, but you know what? Come back in 6 months. We may have changed our mind. Maybe circumstances will change. Do we then have to wait? Is that a formal denial? What if instead there were people running for city council who said, I support this development. We should allow it to have wastewater. We don't need to annex it. Do we have to wait for the election? There's no clear dividing line as a matter of law. That's why it's a question that is vested with the commission to exercise its discretion as to whether when is enough is enough. The final piece I'll say to that is, in most of these cases, we really want to work something out. We work with city staff in cases in order to try to figure out a way. We will offer, like in this case, we offered, what if we did a park? What if we delayed annexation? Which would be important to us because then we could build along our specs before coming in and being subject to zoning requirements. We want to work something out. We weren't able to in this case. But that just goes to show that when things break down and you have the permit, it's up to the commission's discretion. It's not a recipe or an invitation for a city to essentially hold a developer hostage, saying you have to accede to our demands or else you won't have wastewater treatment for anything. I reserve the rest of my time for rebuttal unless for additional questions.
Thank you. Mr. Falk?
If it may please the court, my name is Cody Falk. I'm here on behalf of the city of Georgetown. Thank you, Your Honors. I tried to wear my burnt orange for today. I first want to address some of the questions that the justices presented. But first, I want to start off with one critical piece that I think the TCEQ glazed over, and it's a critical word: all reasonable methods, not just reasonable methods that the TCEQ determines. All. That is what our legislature said in the statute, is that they must use all reasonable methods to encourage regionalization. Now, to the point of substantial evidence and to the issue of Jonah Water's consent, I want to address those quickly. Our reply brief addresses Jonah Water's consent. That question is one that is briefed out, specifically addressed. The city has the right under statute to serve outside of its municipal limits without the need to obtain a CCN. And the only time consent is required is if a district is providing similar wastewater utility service. In the case presented here, Jonah Water does not currently, or, well, excuse me, I shouldn't say currently, but at the time, does not provide retail wastewater service. So the city was well within its rights to serve outside of its municipal limits, and the statutes that our legislature has passed have granted the city that authority.
So I've got to go back to your opening. I mean, what is the significance of the word all? I mean,
Well-
what does that mean, and who gets to determine what it means?
And that is an excellent question, Your Honor. And I think ultimately the issues presented here are one in which the TCEQ is arguing we have such broad jurisdiction to implement the regionalization policy that our legislature has passed that for all intents and purposes, we determine what is reasonable. And we can do whatever we want with regards to it. And then we can act arbitrarily and capriciously because the statute gives us that broad authority. To your question, Your Honor, about when would it be denied, I think it's very important to look at a decision from the TCEQ only a year before the decision in this case. This was the Regal case. It was cited in our briefs at the trial court. I think it was included in it's included in the clerk's record. I know that. That case was a nearly identical requirement from the city of San Marcos that applicants for wastewater service outside of the municipal limits request annexation. And the TCEQ in that case determined that it was not a denial of service to require annexation because the city had the ability to grant a waiver. In that case, the permit was still granted. It was based on other factual circumstances, but the TCEQ found affirmatively that that was not a denial of service. 1 year later, we are in the same position, and the TCEQ arbitrarily decides, oh, well, wait a minute, you can waive this requirement, but we're going to make the determination that based on emails from city staff, not from the city council, that for all intents and purposes, this has been denied. So we'll just move on. This
Well,
denied.
they did ask the city manager a couple of times, right? And the city manager's the chief executive.
But there's an important distinction, Your Honor, in that. The Uniform Development Code that the city had passed specifically stated that the only body that had the authority to make decisions with regards to this is the city council. There was no granting of authority to the city manager or to any city staff that would give them that authority. So we have to follow the statutes and the rules and the precedent that is very clear that we are in a representative democracy. And so our voted for representatives are the ones that have that authority.
I can see that, but they did have, you don't just call up the city council. I mean, you got to get the agenda that says, yeah, you know, and if the deal is, you're going to ask this chief executive, what do we do? What do we do? And he says, you can't do that, you can't do that. And then when you take that to TCEQ, city council said, oh, we didn't say that. I mean, why would you want to deal with a city like that?
Well, that is understandably
Frustrating.
Sure, that could be frustrating. But frustration is part of the process. Frustration
Can we
is,
quote you on that?
yes, frustration is, it's intended to be frustrating. The regionalization process is intended to get people to the table to negotiate collaboration and consolidation to avoid balkanization. We do not want a situation where every corner is taken up by a wastewater treatment plant, period.
Why aren't they entitled to rely on the text of the code here? The code says you have to be annexed. Why isn't that enough?
Well, one, because it's a requirement to file an application, and the code has detailed information about how you may go about seeking a waiver. So the fact that they just ignored it and just said, well, I don't want to have to ask, means they didn't really care in the first place. I think it's important to note that there was a statement made in an email from one of the developers that said, specifically, we do not desire or require connection to Georgetown wastewater. This was not after a filing of a request for a variance. This was not after filing a request for annexation. This was just their unilateral decision to say, I don't want it. You have to go through the process. And I think it's also important to note that there was a statement made by counsel for AIRW that the trial court was mandating that they connect to the city of Georgetown. The trial court never did so. The trial court was making a determination that the TCEQ acted arbitrary and capriciously when it made certain determinations about denial of service and considering factors outside of the TCEQ's jurisdiction with regards to speculative diminution in value.
I mean, but is the problem here, I mean, kind of going back to my ultra-virus question, we have a very broad statute. We have an agency that's coming up with, I don't want to call them rules because they're not rules, but they're some sort of guidelines factors they consider, one of which is other factors. So how as a trial court do you then reverse based on the trial court's definition of a denial rather than the TCEQ's own definition? In other words, shouldn't the agency have some discretion to decide, okay, the developer's done enough here? Or, okay, the city is not being reasonable here. Why can't they look at a situation and decide it may not be an explicit denial, but it's at least a constructive denial?
Well, I think that's important. One, we want to avoid a situation where the exception swallows the rule. So I think the fact that the TCEQ has not adopted any rules with regards to how to effectuate the state's regionalization policy, even though it has been on the books for a very long time is problematic, but that is not the issue here. But I think the question here really is, did the TCEQ act arbitrarily and capriciously when making those determinations, and was it based on any substantial evidence or any evidence for that matter? And taking the TCEQ's how they analyzed the Regal case that I mentioned earlier, one can only make the assumption that, okay, well, based on this case, there is a waiver requirement, so therefore it is not a denial. And then 1 year later, the TCEQ says, "Nah, change my mind. We're going to make a determination now because you emailed the city manager and asked for a non-binding opinion on this issue."
You distinguish between substantial evidence and any evidence. What's the difference?
Well, in this case, our argument is there is no evidence of a denial because the only entity that could give you a denial.
But on the decision itself, I mean, we've got 6 or 7 different possible reasons, and I've always been puzzled. Substantial evidence sounds like more than some evidence, but if you push on it, it really comes down to could reasonable minds conclude based on this, regardless of what the trial court or our court would do, and that's just the same as some evidence. And of course, the problem is if we're looking at an agency decision on some evidence, you can't overcome that with some evidence of your own. You've got to basically have conclusive evidence. That's the only way to beat some evidence.
And I think
that's extremely hard to do.
Well, the question is, was it reasonable for the TCEQ to conclude that the city was not going to grant a waiver? Was that reasonable? So in Heritage,
Substantial evidence, we have to not just that there was substantial evidence to support it, but it was reasonable, the decision they made based on it. That's not our job, is it?
in Heritage v. TCEQ, the Third Court of Appeals concluded that it must remand for arbitrariness if it concluded that the agency has not genuinely engaged in reasoned decision-making. Is it reasonable for an agency to ignore court precedent? Is it reasonable for an agency to declare that the actions of employees bind the city? Is it reasonable for the TCEQ to ignore the law? Would it be reasonable for me to conclude that the statements of a law clerk of the 15th Court of Appeals binds the justices? No, it would not.
Well, to me, the distinction seems to be that there's not an actual provision in the law that requires a formal proceeding here, right? A formal request to the city council and a decision by the city council as a whole. Like, we're not dealing with an issue of exhaustion of remedies, right?
So fair enough, Your Honor. The question is, we are not dealing with a rule or statute that says denial. We can only base it on two real important things at the time.
And what are the two?
The two things are the TCEQ's webpage guidance with regards to regionalization and the form requirements of a TPDS permit application. And the TCEQ's the webpage said that there was a denial of service. Not an effective denial, not facts that would prohibit, not statements from agency staff that would equate to a denial. And the TCEQ interpreted their own webpage guidance in the Regal case to say having this waiver was not a denial, but then subsequently, a year later, saying, ignoring that fact. So the TCEQ is acting arbitrarily by just saying, moving the goalposts every single case as to whether or not that is required. So in essence, to your question about whether it's an exhaustion of administrative remedies, really it's the TCEQ's webpage guidance at the time that required that exhaustion of remedies. You had to show in your application that you reached out through certified letters to the specific other 3-mile wastewater treatment facilities. You had to show that I asked for service and I was denied.
I mean, it
And-
sounds like you're arguing that the website guidance is a rule.
Well, for all intents and purposes, that was the only thing that could guide this proceeding at all. I personally think that it is fundamentally flawed that the TCEQ is acting ad hoc and not using the Administrative Procedures Act to develop actual rules. So the only logical conclusion is if they can change the web page at any given point that is not following the Administrative Procedures Act, it's ad hoc, it's arbitrary. And so only using the web page guidance at the time, that's the only thing we could use, and that said denial. It didn't say
What if they
effective.
didn't have a website with guidelines on it? What would be the situation then?
Well, I think in that hypothetical situation, again, we would only be guided by the statute, which gives them broad discretion, but it still is, it's permissive in areas and it's mandatory in others. But again, going back to my original point, it says all reasonable methods, not just the reasonable methods that the TCEQ determines is in their best interest.
But who else would?
Pardon?
Who else would determine what all means other than TCEQ? I mean,
The legislature?
well, I mean, they had a chance when they wrote the statute. So what are they, I mean, is it an individual legislature? Is it the body? If it's the body, it's the statute. So once they write all reasonable, who else gets to interpret it?
Right, well, and then that is the question of, did you act consistent? The court is tasked with asking, did the agency act consistent with the statute? That is your job. Did they act within and consistent with mandatory provisions of the statute?
Right,
Did
but-
you exhaust all reasonable methods?
But if it says all reasonable methods, and the question is, did you exhaust everything in the statute? How would they ever know, if it's not up to them, what is reasonable? How would they ever know that they exhausted all reasonable methods? You see what I mean? It's just kind of it's a big circle.
Hence the problem with this proceeding in its entirety, because if you adopt the TCEQ's interpretation of the regionalization statutes, the exception would swallow the rule. There would be no situation, period, in which a court could make a determination that the TCEQ acted arbitrarily and capriciously because, with regards to regionalization, albeit, that there could ever be a situation where you could challenge it. It's just meaningless. It's the policy, and that's it. And we cannot render a statute meaningless. And for all intents and purposes, if we adopt the position of the TCEQ in this case, we would render it meaningless. We would result in a complete lack of regulatory certainty. I do want to address the property
What
values.
is the, let me skip down to one of your other arguments. What's the difference between a green space and a vacant lot,
For purposes of
whether it's a park or not?
well, I think there's statutes on the Texas Parks and Wildlife there that do control what is and what does not qualify as a park. And I think that's an important question as to the AIRW's counsel was presenting as, well, we were offering these things. We were offering a park. We were offering this. We were offering delayed annexation, et cetera.
Well, it was also wasn't in the context of the odors and air quality.
So there are certain restrictions on how much space is required, and I apologize for not memorizing this, but I think it's between 15 and 20 feet, but I cannot remember
It was
specifically.
150, but I
Yeah.
also stand to be corrected.
Right. So there are certain requirements on that from our perspective, the TCEQ did not fully evaluate in the process of reviewing this application. There were numerous aspects of the technical requirements that the TCEQ did not conduct a full examination of, and there was ample administrative record evidence discussing that.
So how long was the administrative process? How thick was the administrative record before TCEQ?
Large. It was a very large.
Because, you know, this is I know that we are a court of law, not a court of the times, but there is a widespread agreement in many places, not all, that, you know, at some point we got to make a choice between, you know, are we going to spend 10, 20, 30 years scrutinizing over snail darters and other things, you know, especially like in Alaska where the indigenous peoples say, please come drill, we need the jobs, and everybody, no, 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 because, you know, you got to start all over again with the EPA, and you know, Congress is, I'm concerned. I want clean water. I used to live in Georgetown. If I lived there, I'd want clean water too, and I wouldn't want a wastewater plant next door to me. On the other hand, I'm not an expert at those kind of things, and the fact is, you represent a burgeoning city where, frankly, the traffic has gotten nothing but worse in the last 5 years. And, you know, these people got to live somewhere, and we can't keep sending them further out, or I-35 becomes impossible. So we do our best, we send it to this agency, and you're asking us to send it back for one of your requests. We send it back for more stuff, and I need some compelling argument why that's a great idea.
Well, I'm 30 seconds in, but I can.
I just used up your last minute.
No, I apologize, but for all intents and purposes, what the city is asking is for a full regionalization analysis be conducted, and that the process of an actual denial occur, if that is actually going to occur. We're just asking for the process to be employed in the way it was intended, to avoid a situation of balkanization and an increased amount of points of pollution. The more plants we have, the more opportunities, points of failure that we risk, you know, polluting our sources of water. That is all we're trying to do here, is to make sure that the regionalization analysis is done as intended by the legislature.
Anything further?
Thank you, Your
Mr.
Honors,
Falk.
for your time. Thank you.
May I please record? Thank you, Your Honors. So I think there's an interesting line in the Texas Supreme Court's decision last term from Save Our Springs, where the court effectively says those fighting against a permit may dislike the breadth and the discretion that's given to an agency, but that doesn't mean that that's what the statute says. Right? The statute gives this discretion to the agency, and they exercised it reasonably.
But are you constrained by the website?
No, certainly not. So the website is not binding as a first matter. And second of all, the denial argument is a constructive denial, which is reasonably interpreted. All the time in law, we have provisions where the courts interpret them as constructive denials. This is all over both federal code and Texas code. It's not unusual. But the guidance is also clear that it's not exclusive. Right? This is just an information about how they will typically exercise their discretion. It's not binding them to only these 4 circumstances. I think it's also important to recognize, my friend mentioned Regal a few times, which is a different decision. I don't want to get too far into that. I think there's a reason that it wasn't in their papers here, because it just doesn't jive, which is, in that case, the commission specifically said that there was an indication that the city would waive. It found the exact opposite in finding a fact 41 in our case. This just proves that the commission is looking at the facts and making a reasonable decision based on the facts that are in front of it about whether there's actually going to be an opportunity to negotiate, to figure out a way to connect or not. And to go further on that a little bit, to talk about the city staff and city council argument just for a second here. We've never argued that the city council is bound by the decision. That goes back to the constructive denial point. Right? It's constructively a denial because what is being required of us is essentially to have to go through a bunch of bureaucratic and political hoops that there's been no indication would ever result in anything favorable, just creating more delay and more process.
Well, and if you were to require a city council denial formally under the guidance of the TCEQ, wouldn't the TCEQ then be at risk for a suit for improper rulemaking because they're applying that across the board, that it has to be a city council denial instead of considering the factors or whatever happens in the situation?
I think so, and you could get litigation on that side as well. And I think it's just kind of a strange argument in some ways that they're making here, because it's not as if the people we were talking to were some people off the street that we pulled and said, what do you think about this? They were agents of the city representing the city's position. Now, to be fair, they weren't delegated the authority to bind to a contract. What normally happens in these types of negotiations is we work back and forth with city staff. We come to hopefully a development agreement which says, we'll do this, you'll do this, here's our negotiation. We won't annex, but we'll give you this, or we will annex in exchange for that. But we couldn't even do that with city staff. We said, what if we did a development agreement that didn't do this, didn't do annexation, but we'll give you other things? They said, absolutely not, we're not doing it. So I guess somehow we were maybe supposed to draft unilaterally a development agreement and then try to get it on the city council's docket and make them take it up, even though it's their discretion. So if they just punted forever, never put on the docket, are we just in limbo forever because we don't have formal denial? Like, these are all questions that should be resolved by the commission, and were resolved by the commission. It's a functional inquiry about availability. They did that here. When it comes to the position about swallowing the rule, I think that's just not going to be the case, because the commission has the ability to look at the facts in every example, and if there are facts that they think means that there's still opportunity or that doesn't encourage regionalization, they can require something more in those cases. That's just not this case. And in most cases, it's never going to even arise, because if there's a reason why we could connect, we certainly will. Like, talking about frustration, we filed in 2020 for this permit. We took 3 days of a contested case hearing. We then had to go all the way to the Travis County Court in order to then come up to this court. We're still just trying to get a permit. It's extremely frustrating. The commission is the one that should resolve this. This court should make clear for all future developers, people, applicants, that there should be a back and forth. But ultimately, the commission has the discretion. There are multiple reasons here: the denial, the cost, Jonah Water being the one who is the service provider that they would have to go to and get consent. Funny that they don't need consent from Jonah Water, but we need a formal denial from the city. Doesn't really square in my mind. But at the end of the day, this court should reverse. It should render so this case doesn't keep going back and forth, and we thank the court for its time.
Thank you, counsel. The case is submitted. Marshal will adjourn the court.